trenger bare å tenke på det. Okay. Good, Daniel. Yeah. Okay, good, great. Okay, thank you everyone for being here and welcome to this session on child rights. We have already had two very, very good sessions setting the global scene. Today we are going into child rights specifically, and we're going to talk about one part of child rights, which is children's participation. Children's participation is one of the pillars in the Convention on the Rights of the Child, and it's a very, very important right, because that gives children the opportunity to have a say in their own life. It gives them the kind of opportunity to be a part of what's going on, to be a part of what it is to be a human being in our society. And if we look at the developments, we will see that we have given more and more rights to people, to minority groups. And I think that now we also see that children are coming up on equal footing as many of the other members in societies. But still, this is a very, very difficult right to implement. And we can see this across countries in which you see that even though they have these strong rights in legislation, in the convention, of course, but also in various regulations. And we see that in the professional ethics, that you should include children, you should have them as a kind of a part of a process. We still see that we do not succeed. I mentioned previously that we have in Norway and in Sweden and in Iceland and in Mexico, the CRC is the legislation and the law of the land. But still, this is difficult to implement. So what we're going to discuss today has a general purpose and a general importance, but we're going to use the Norwegian, primarily the Norwegian case as an example. And today we have then brought up four, but we're also going to include some of the other countries. Today we have with us some very excellent panelists are going to talk about the right to participate, and especially within the child protection context. And this is a difficult context because we know that here there are a parental right situation, there is a child right situation, but there is also a state situation. So there are kind of three very active dominant parties in these cases. Together with me today, I have researcher and political scientist, Audun Løvli. So he will start and opening up, say a little bit more about the legislation, the framework, but also the legal cultures and how the judges think about children's participation. Secondly, we will have Dania, which is an expert by experience. So she knows, and she's going to talk about where do the shoe pinches? What do the children themselves experience? And Dania and Marit, they are both from the Change Factory, and that is an organization which is then consisting of experts by experience in various areas. And they have been very, very fundamentally impacting the Norwegian society and how to think about how it is to be a child and to meet the welfare state services, to meet the court system, and to meet the educational system, for example. Very important. Then we also have Professor Tarja Porso. She's a professor in social work. She is the leading expert from Finland, and Finland has had party rights for children from the age of 12 for many years. In Norway, the right to be a party in a case is 15 years old. So this is an ongoing discussion because we don't think that children at a lower age would be able to use these rights. In Finland, they've done that for many years. And then finally, we have with us Taba Diek. She's a PhD student in political science from Germany. You're a master student. Oh, but after PhD course, you have, okay, thank you for correcting me. So, but still, she is working on a super interesting project on foster parents, which are the everyday heroes of so many societies, and how they are able to be a facilitator and to helper for children that shall participate. So by that, I will give the word to Audun. A reminder, we will have open the floor for questions after they have presented insights, and then we will have a discussion. So, Audun, welcome.
Thank you. And thanks to the Bergen Exchanges team for having this roundtable and giving me the opportunity to come here and talk about our project, the Children's Right to Participation. That's a bit of a thing. So it's probably important to start by saying something more about the Norwegian context. So I'm just going to go straight into this, and that's the Child Welfare Tribunal is a word that I will sort of come back to and use a lot here. And we should consider them an additional court, a first instance court, when it comes to coercive interventions in the family. And they deal with only that, or primarily those kinds of cases, care order cases and foster home placements, etc. Their decisions can then be appealed, so to say, whereupon then the case is fully reprocessed in the district courts. And tribunal leaders, like judges of the courts, are independent, not via the constitution, but in law. And they must then, within their sort of discretion, ensure children's participation in cases as per the law that the law sets out. And in the Norwegian context, as Marit talked about, children's participation is enshrined in the constitution and is further detailed in section 1.4 of the Norwegian Welfare Act of 2021. And it can be summarized in 3 points. Children that can form their own opinions or views have the right to participate in all matters that concern them. And they should be provided adequate and adapted information in order for them to be able to have an informed opinion. And children should be listened to, and their opinions should be weighted according to age and maturity. So already now we can see quite a few dilemmas sort of preparing, like also in the previous sessions. So to assist, so these are then the structures for these organization and the organizational units and these professions, these judges. And this is complicated, as we've talked about today. So then what do they do? Well, the decision makers then, in meeting these structural requirements, the district courts and the child welfare tribunals, together with the respective central administrations, have developed their own guidelines. These are tools to assist decision makers in facilitating and ensuring children's participation. And this is in sort of optional self-imposed influence on their discretion. And then participatory practices of the tribunals, as Marit mentioned, vary. They vary between different organizational units that are in different geographical locations, and they vary within the same organizational units. So then the questions then we ask in our project, they are, how does this work? These guidelines and these decision-making processes. How are these guidelines utilized? And what if they are the characteristics of these court or decision-making cultures in these organizations and within the individual organizational units? We know from the literature that there are several different dilemmas. Maybe Dania can talk more to you about in a bit about the participation, about participation that concerns questions about age, maturity, and responsibilization, and of course, decision makers' independence. So for this project, or this part of the project, our project, I interviewed 15 judges with leadership positions and advisory responsibilities. We call them sorenskrivere, or magistrates. They're the head judge in court, and then 10 managers from these tribunals. And these interviews were aimed at the impressions, or these leaders or managers' impressions and use of these guidelines, what they thought the judges, their employees, how they used them, and so on, as well as their own experiences and the perceptions on participation and these related dilemmas. So then how do they, within their organizational structures, resolve these challenges of informing children, talking with children, and the potentialities of role conflicts, and of course, the difficult questions of burdening children with too much information or too little information, and the responsibility that children can then sometimes feel throughout this participatory process. And of course, how do they assess maturity? Is this just an age as a proxy thing, or is it something else? So this is kind of what they said in brief. They were all positive about the guidelines, but not everyone had read them. That was sort of the starting point. But they're very positive about them, and they were quite sure that most of the judges would be aware of them. And judges in particular, more so than the tribunal leaders, expressed hesitation about talking with children. And this is because they do not feel like they have the competency to assess and talk with children. But also there's the dilemma if there's new information that comes through this participatory process, like new evidence, then the judges become witnesses. And this can be a challenge to their neutrality and their independence. This has to do with how participation is supposed to be conducted. And of course, there are several other dilemmas related to loyalty and the burden of too much information, as I already mentioned, and this responsibility feeling. And looking into how they reply to questions about, or how they talked and they replied to questions about responsibility, there were sort of two main manners that they were that they problematized. First is that they problematize children feeling and experience responsibility for the outcome of the case, which then could lead to hesitation or resistance to participate, or result in opinions being aligned or influenced by the wishes of their parents, i.e. what in literature would be called inauthentic participation. And second, children that carry extra responsibilities at home was problematized with regards to threshold and maturity. And I think this is quite interesting. Some responsibility can make children more mature. And they implied that this could make that their opinions could carry more weight when they participate. But simultaneously, this extra responsibility could also make children too mature for their age. For instance, if they take care of and protect parents when they're intoxicated, or taking care of older siblings, and so on. And in this context, the question of the child's best interest, which we talked about earlier, becomes as kind of like a counter argument to the participation, or the weight given to the participation, or their opinions. And then finally, because I'm probably over my time, well over my time, 1 minute. Okay, great. That's not bad. And this is maybe something we can discuss more. And that's this difficult challenge of assessing maturity, because I did push them. I did push the judges on that because they didn't want to answer. So I kept asking. And while they'll rely a lot on other actors' descriptions of the children, such as child protection workers, teachers, experts, parents, to get an impression about this, several of them also found it very important to meet the child to get that impression themselves before they made maybe a final decision about participation. But in generally, I found two main categories that about maturity and how they assessed it, and that they highlighted competency and experience. And competency refers to the children's eloquence, if you will, their ability to justify their reasoning for their opinions and wishes, as well as their actions, consistency over time in actions and in opinions, and what the decision makers would call intellectual functioning. They did not really elaborate on that, but they would use that word. And by experience, they refer to children's experiences with the child protection services, welfare services, health services, diagnoses, their own or parents or siblings cope with or deal with and live with, the suffering that they may have experienced through neglect or violence. And this again also ties back into the responsibility sort of statements they made, like how important responsibility is. So it sort of all ties together. They're quite intertwined. My time is up. So thank you very much. And now I yield the floor to the Change Factory.
So thank you so much, Oda. This was great. And I think you have given us a very good platform to continue the discussion. And then the question is, Dania, so how does it feel? What is it, this system? You're welcome.
Thank you. First of all, I'm just going to say you introduced me as an expert of experience. And in the Change Factory, we use the word pro because you're a pro in your life and in the systems you are in. And as a pro, you don't talk so much about your own experiences. Your kind of job is to talk about the knowledge that Change Factory collects from many children. So it's not me just talking about my experience, but from a view from more children. You want to fill in about the thing? Okay. So Dunya talked about a lot of important things and both structures to assist and dilemmas. And one of the things you talked about the new law and the paragraph 1.4 about that children in all matters affect them should get information and talk safely and have a person they trust with them. And that also the child protective service should protect the things the child says. And when you talk about the dilemmas, one of the things I think is important is the view of the children. Because as you say, there's a lot of arguments, and I know it from my life too, that you're not mature enough. Maybe it's hard for you in your life situation to talk right now to the people deciding, or you're doing a lot of things that's not good for you. So we can't weight the things you say so much. But from children and from me, there's always a reason behind the things we do. And if we tell different things to different adults, it's a reason. It's because of trust or safety. And it's a bit scary. And I know you didn't make the convention on the right of the child, but I'm talking about the maturity of the children, because two different adults can talk about the same child as two different stages of maturity.
And you also know that you told different things to different adults at the same time. So that's also a point we often hear about with children. So can you remember when you were, for example, because I think that's an example, and that's how we use it with one another. They can tell examples from their life. So you remember when you were, for example, as you told many times on drugs, or you were talked about this too?
Yeah, I could tell some adults when they ask me, okay, what do you need? I just want to use drugs. I don't want to do anything else. I don't want to quit. And then they decide, okay, we can't listen to her. We have to decide what we are going to do in her life. We have to move her away. But to another adult that talked to me different and talked to me like they gave me enough information, because they didn't think that keeping information away from me was protecting me. And Job worked a lot with trust. I could tell them that, no, I don't want to use drugs, but I need the right help. I don't want to get moved far away, because I know that's one of the types of help you can get here in Norway. So it was two complete different things I told to different adults.
So when these guidelines were made, the state came to talk to you about trust. And they had lots of meetings together with young people, because they wanted to really find out what is it about trust. Because like you say, and like many of the children say, this is the whole difference. And then it's the big question, how can this be put into the court? So, and what is deciding what to tell in court, or what is important with the court system? Because what if you mentioned the judges wanted to talk directly to the child, for example, and you fought for that.
Yeah, we fought for that, because some people have talked about maybe it's not good for children, or you give them too much responsibility. But from my and from children's point of view, it's in the court, they are going to decide maybe some of the most important things in your life. They're going to decide how much you're going to see your parents, or where you're going to stay. Of course, you want to talk to that person that decides. And maybe you didn't have that trust to the child protective services. But when you know this is the last person that are going to decide this, you might tell something different to that one person.
And this whole person the system with the because that's also used a lot in
Yeah, and that's kind of a new person coming into your life and just coming to talk up to you about what you feel or what you think, and then they are going to the court and talk for you. And that's again a bit scary thing from children.
So lots of children, when when they do speak to the judges in Norway, they ask them to, they don't think so much about the competence, because you have competence, you say to all of them.
Yeah, if you see a child on the street, that had fell from a skateboard, you go to the child and talk to it, because you know that you can talk to children. But why is those children coming to court so different?
And it's also scary with this competence thinking, what the children say in Norway, because I'm not in our countries, but we are traveling around now, and these thoughts, they are very, very interesting. We see when we go to other European countries also, because the competence idea, it's also a very scary idea. The children say, not black and white like that, but there are lots of things about it, because you can kind of catch it when they get too much confidence.
Yeah.
The simple way.
You can catch that person in front of me is an expert on talking to children, and you can see that they have kind of some expert glasses on, because they know so much about children and from children before, and about how children develop, that you
Talk to them.
and how to talk to them, to feel that it's not naturally that talk.
These are hinders seen from children. And that's the change factor idea, is to try to find out what is seen from children. Because very often things we think, for example, we ask children in childcare institutions who are going to work in childcare institutions in Norway, and they say anyone but not childcare workers. And that's it's sad. And then when we try to find out, we found this thing. So that's not even black and white, but the thing is to find this out from children. And then to change the law, for example, because you were one of the people changing this childcare law. Yeah.
Thank you so much for this kind of opening up on this very, very important child perspective. How does it feel, and how does it being experienced from the child's view? So thank you for sharing this. And of course, as already mentioned, they have done a lot of research or collection of data from children that has been in the system. So that's extremely good. One thing I wanted to just kind of not to answer right away, just kind of give a little think, is kind of, so what do we say then to the judges that say that, well, we need to protect children because this is different cases and can't get too much information, and this will make it difficult for them. So give that a little think, and maybe return back to that. What you also underscored, it's important to be safe. And you also discussed the question of competency. In Finland, we have different approach to competency. And as I mentioned, you already have kind of established a lower age limit for being a party to a case. And also you would require the children to participate in saying yes or no, simplified said, to a measure or a service or an intervention. So Tarja, would you please learn us a little bit about the Finnish way of doing things?
Thank you. Yes, we now move to Finland and its child welfare system. As you said, there's a lot of regulations about children's participation in the legislation and guidelines. And I'm now going to talk only about one small detail, and that is about children who are 12 years of age and older, and how they are involved in care or operations. As children of that age group have the same rights as their parents to have an impact on the process, whether the child should be taken into care or not. And one could think that this is quite a sort of high standard, quite form of participation. And this is, I understand it's very different from other Nordic countries, and we haven't come across it elsewhere. One reason can be that our decision-making system is different from the other countries. But I'm focused on this issue of children aged 12 or older, either consenting or objecting the proposal for the care order. And one other reason why I focus on this is that we just finished a larger study on this, in which we interviewed social workers, parents, children who have been with case files and legislation, many other things. So I will pick up the critical points. I mean, I'm not saying that the system does not allow children's participation, but I pick up the critical points because it's important to notice that it's not only enough to have the legal norm or the legal guidelines, it's much more. And as Marit, you said, this has existed for decades. This is an old system. It has been in our legislation for several decades, even when the Child Welfare Act has changed. It is in our guidelines, it is in our professional education, it even exists in our client information systems, that when you prepare a case, you have the forms, templates asking to learn about the child's opinion. So it's sort of, one could say that it's part of our everyday practice, and it indeed is. But the critical point is that it can, as it is so much of a everyday practice, it can also become just a formalized element of participation without being any form of meaningful participation. It's followed, but it doesn't always have the meaning of participation. And that is, I argue this, that these norms and guidelines and regulations, they are put into practice in interaction. And interaction is extremely complicated, and I think we already heard about it. And interaction needs so much more than just guidelines and norms. It requires skills and case-specific skills and willingness to face with uncertainty, and there's a lot of need of time and so on. And what I found in our study quite challenging, which again is something that you already mentioned, was that when we asked social workers who are the persons preparing for making the preparations and that is elsewhere too, whether they thought that children are competent to express their view or opinion of consent or objection. So they said that yes, of course they are. Of course they are competent. And we got trouble with this of course thing. But this is very difficult. I hope you don't misunderstand my point. Because they say that children are competent, but of course they, in the moments of these discussions, they must have had quite difficult times. Some of them had run away for weeks, some have been using drugs, and they had a lot of things going around in their minds, but of course they were competent. And my argument would be that one should somehow expand the idea of competency. Because if you see someone so competent, then it might mean that you don't provide the support and extra information and time which might be needed in that situation. So competence is something which takes place in contexts, and you should somehow support that context for the child to be piece of the opinion. And I still say just a couple of things, and these might lead, when I say the meaningful participation, that we can come up with forced participation, because it's part of the bureaucracy system, but if it's not supported by good interaction, it's forced participation in use force. That was a critical point.
Thank you, Taya. And this is very, very interesting. And I think we will also pick up on that one afterwards on the fourth store. But also, I think it's very interesting that you highlight that that you would, when you take it for granted, you don't even kind of perhaps provide sufficient support, information, etc., to the child. And I think that's actually kind of a good way over to your presentation to work, because you're going to say something about the parents and how they can facilitate and support children's participation.
Thank you very much. We heard about grandparents, and also the information, interaction, and having the perspective of both the parents also makes an important part that we talk a little, and I will talk a little bit about how foster parents can be seen this cultural development and role that and facilitate the fulfillment of children's rights to participate. And my perspective is from Germany. Based on closer interaction with foster children and foster parents, as well as the cases I have seen in my work, I can shortly and sadly summarize the situation. Best interest and a child's view based on maturity and age are the most important factors and commitments for decision making. However, in practice, the focus is not on the children themselves, but rather on protecting the biological parents. This is common in legal decisions and custody proceedings and indicate that the participation of children often does not play a significant role in a process. I would go further and claim that sometimes the best interest of the child is not clarified, defined. For whom is it the best interest? Looking at the legal cases in Germany, usually what is protected most is the traditional construct of a family, with children living with their biological parents, even when this puts the children in danger. Once a child is placed in foster care, contact with the biological parents often continues immediately, even during the processes. In many cases, legal custody remains with the biological parents. What does it mean when legal custody remains with the parents? It can mean that decisions such as medical, educational, or other choices are made by the biological parents and can significantly impact the child's life. Just to give an example, from also a perspective as a nurse, if a foster child in Germany is rushed to the emergency room, it is not enough that the foster parent signs the legal and medical forms to ensure the necessary medical treatment for the child, but legally the doctors and nurses have to wait for the biological parents to sign these documents, which of course can lead to crucial delays in the medical treatment the child needs. The question that arises for me here is, how can a child participate in important decisions, whether they want to see the parents who have abused, mistreated, and neglected them, especially if the child is frequently obligated by law to meet with their parents. What I know for sure, children always communicate what they want and what they don't want, but in a different language that can be difficult for judges, experts, social worker, to interpret. They may stop eating, show extremely physical reactions after meeting their parents, faint during the meetings with their biological parents, scream, have trouble sleeping before and after the meeting with the biological parents, or develop nervous habits. The main problem lies in the assessment of the child's maturity by decision maker, and more importantly, in obtaining all information about the child's true needs and will. Children, especially with maltreatment experience, often struggle to clearly articulate their feelings, which puts them at a disadvantage when trying to express their wishes. And here's an example of why foster parents are crucial to the structures within a state to facilitate children to participate. My whole hypothesis is strengthening the legal authority of foster parents to have a say could enhance children's participation in Germany. First, how is the relationship between children and foster parents?
Foster parents have the closest bond with the children. The most significant caregivers for children are foster parents. The children repeatedly develop trust in the parents, resulting in a kind of temporary family. Foster parents usually have extensive information, and that's really important, and are in a position to access the children's needs. In terms of the structural legal culture, they could verify the children's statements as they essentially serve as witnesses to events, especially in the most cases with interaction with biological parents. There's no ambivalent relationship as often seen in biological families, where children might face more obstacles in expressing their true needs due to not wanting to upset their mother or their father. Lastly, there is a potential in the fact that foster parents already exist within the structures and could play a supportive role in child and youth services and assessments. The will of the child is incredibly important, and especially in cases where the best interest of the child and the opinion of the child diverge. We need more evidence. Should I stop?
And we need more evidence.
We need more evidence.
Okay, thank you so much.
During the Q&A. So we will open up the table for questions from the audience. But before I do that, while you just think about your questions, I just wanted to ask if there anyone that wants to share some reflections on the what we have heard so far. And I see that are you nodding, Dania, for that you want to say something, or are you just nodding because you're positive?
Saying something. And
yes.
Today, and both in this panel here and earlier today, we have talked a lot about, or the best interest of the child has been something that has came up again and again and again. But how do we know what is the best interest of the child? And I think I really support the things Asgeir said earlier today, that we have to start with each child. Each child is different. And having a checklist or something we don't know if we do it right or if we miss totally when we start with something like that. We have to start with the child in front of us and their opinions, and then see, okay, what do we do now? Because children can feel if the adults isn't coming clear-minded or having some opinions when they're coming into the room, and that can make the things the child says completely different.
Thank you for sharing that. And actually, I would say that in most of those checklists, you would have the child's opinion and viewpoint as one of the most important checkpoints. So then it's open for questions. Siri, I would throw it. Yeah, and then we have one more back and one more back. So you just throw.
It's an advantage because she used to be a handball player. I have a disadvantage because I'm terrible with the ball. Okay, so this was just extremely interesting, and I want to start by taking up the last point because it's so it reminds me of there are many places where we do checklists. Like we call it different things, but for instance, at hospitals they do it a lot more now, and it's really difficult because if you have the perfect person takes everything into account and comes up with a perfect solution, the checklist is a worse option. But if you don't, if you have sort of someone who's not really open-minded, who's not really looking at the person in a total, then you would like the checklist because it's at least better than the judgment of someone who's not really the best person, which makes it super difficult, which is probably what was Smart's point, that one of the most important things to say is listen closely and look at that person in front of you and be open-minded. But it's actually really difficult. And I think that is one of the, it links a little bit to our discussion in the last session as well, that when we move to a way of thinking of the relationship to the the welfare state more in terms of a contract. It's also sort of saying, okay, as welfare users or clients, we're entitled to an equal position. You can't just decide what's best for us. And that is the good part of that. It's sort of the good thing, but that sort of results in checklists, because it means that the system will have to say, okay, we need sort of to have a list so that we know that we do what we're obliged to do. So you're pointing to something that is like at the core of this dilemma. So I'm sure there are other people who want to talk. I just want to say that first.
Okay. Thank you. This is a super interesting panel and connects to lots of the things we've been talking about over the days. And I wanted to ask on the question of information, one question on information and one question on the ability to hear things. On information, I'm thinking particularly about the question of trans children, which is such a field of contention and mobilization by all of these networks we've been talking about in the previous panels, and where the evidence or the information that will need to be given to children is hugely contested, right, and a moving field. So in that field, what kind of guidelines or decisions about the kind of information that children need to make an informed decision in this contested field? So I'd like to hear something about that. And then on the question of how to listen, I was thinking particularly not in the context you're talking about, but in some of the Latin American countries, I know about child protection cases involving indigenous children who have other ways of knowing their worlds, right? And what you normally have child protection systems hugely inflected by structural racism with very little dispositional capacities to be able to hear what those children might be saying. So I wonder if that's also a factor or an issue in the Nordic countries about epistemological difference. Yes.
Thank you very much. It's been very insightful. So my question is has to do with child welfare workers, the people that are actually the bridge between children in care and the system. I want to, maybe you guys can, enlighten us on how important they are in terms of what they do. For instance, in Norway, we know that about 80% of care is actually like what they call like the in-home care. And most of these things are run by child welfare workers. Some models of decision-making in child welfare work also strengthen what they call organizational factors as very important in making the right decision about the best interest of the child. So I want you guys to talk to like enlighten us on how or what you think about the roles of child welfare workers themselves. And then also regarding that, one of the panelists talked about how when you meet child welfare workers and they come with a lens of pro or experts, that is some sort of a hindrance. I also want to, like, regarding that, I want to, like, what do you think? Because in Norway, for instance, and also not just in Norway, in most of other countries, there's a lot of high turnover among this work group. Sometimes some offices face about 40% of people within a year quitting their job and going somewhere else. So in your experience, how has that affected, how could that affect children? You know, like when you have to talk to one person on Monday and then in 2 months, it's somebody else that's in charge of the case. And then in 6 months, it's somebody else. How does that affect the relationship with child welfare workers? Thank you.
Yeah, sorry.
May I just quite quickly, thank you very much for all your insights. I'm really appreciative of the information and the exchanges you are facilitating. Just my question is on the temporal aspect of children participation. Are there cases you've come across with in which at the early stages they have allowed for children participation fully, like in a more liberal way, and afterwards, like this case turning out to be in detriment of the child, meaning that the child afterwards changes his, her opinion, and then regretting that she has taken or took the decision before in other circumstances. So the extent to which meaningful child participation at early stages, the implications of this over time as he or she grows. Yeah. Throw it.
You don't take any chances. Yeah. Okay, thank you so much. This was super interesting questions. Point on. So I would just give the word to Audun, thereafter Tarja, Dania, Marit, and then Bob. Okay. And it is.
Thank you. So yeah, that's lots of good, to the point,
A good reminder.
difficult questions. So I don't even know where to start because they're all very. I should pick one. So I'll pick the easy one then. Because there I know the answer. So about the turnover of social workers in child protection. I mean, of course, you can probably speak a lot more to that than me, but I would think that has a detrimental effect on the relationship between children and the system and their relationships in this process. So yeah, I think in very short, yes, that's not a good thing. Yeah. So yeah, yeah.
Okay. Then we give the word to Tarja.
I react on the last comment first, because there's something I really want to share based on our study in which we learned that children, when they were already young adults, felt very bad about the processes in which they had been asked about their opinion about matters they didn't fully understand. And that's what I meant with the term forced participation. And it's not only about understanding, but it is about being dependent on other people, being living in those power relations which you have when you are in the system and when you are a member of family. We talk about family relations here, and they are relations of emotions, but also of power. And I think one should be more aware of these problems as well. That participation is not, it can have these unintended consequences, which was the term which was used before. And then I would like to comment about these checklists and listening. I would add a third element. It is about thinking and understanding, and somehow understanding about children and childhood in difficult conditions, or in difficult is something like there would be just one type of difficult, but in complex life situations.
Thank you. Dania, Marit.
I'm just trying to think which question. So if anyone had a question for me or us.
Yes. I think I will go into two of them then. One is about, just as I asked you previously, kind of what should we tell the judges that are so afraid of being kind of that hurting you, the children, or that the information that they give are not sufficiently adapted to the children. So something about that, which is also relating to the child's best interest. Yeah.
And I think the most important question, my answer to this is with interacting with children, giving information, it's from children the best way to protect them. Because first of all, it's their lives and they have to live with the consequences of what's happening afterwards. So, okay, maybe we're thinking we're protecting them for not asking them to say something in that situation, but they are going to live with the consequences after that. And children knows a lot of things that adults and the judges may not know about their life and their situation, and that they haven't told anybody before. So I don't know how judges can decide without knowing from children directly.
You also found out in the comments, we found out that it's saying in there that when a child has been used force or power, then you should listen better.
Yeah, that the rest of the process shouldn't take more of their autonomy away from children. And that's the way to strengthen children again.
That's often the opposite of what we're talking about in Norway. Then we say, if you are abused or if it's, then we should protect you more. But in the comments, it's the opposite.
Oh, thank you. Thank you for sharing that, because that's important to know that you shouldn't take away more autonomy. Yeah, thank you for that.
I hear in the audience about organizational practice and that social workers change a lot. In Germany, we have the same situation and they decide a lot for the children. And so there's often no relationship and also no trust. And from a perspective, I work with a lot of children, foster children, and also as a nurse, my perspective is that we need a bigger approach, also a more interaction in the places where children have relationships, like in hospitals, schools, with the teachers, friends, foster families, or it needs relationships that they can trust and tell what they would not tell to anyone. That's really important.
Thank you. And then Marit, you full
Just very short.
tiny comments.
Also from many of the surveys, we can see that it is important with the adults being there over time. But even more important is adults making trust. So we shouldn't be so afraid about changing adults because we can think a new adult can make trust very fast, say as children. And that's, I think it's important to remember, because the system is like this. The adults are changing, but we should focus really, how can you make trust fast?
Yeah, maybe if we focus on that, maybe less adults want to change their job. Maybe it's more fun and more important to work in these services.
Thank you. That is a good one-liner. Kind of, we need to make trust fast. So very good. Thank you, people. We did not manage to answer all questions. We have something left about indigenous peoples. We also have something left about the crowns. If we just can collect here, so people can go to a break, but still, if someone wants to continue conversation, we can meet down in the corner there. So thank you everyone for your attention and for your time. And thank you.